Let's go with another round of When I'm Not Podcasting. Thanks for being here. King of Podcast here with you. Billboard. And I'm looking also at Deadline.com for the story from the Supreme Court. This is a huge thing that I've always been worried about because of the infamous 1996 Telecommunications Act. Because with corporations being allowed to grab so much, and be able to merge and be able to go ahead and acquire so many different properties and acquire their own competition or acquire properties as part of another company and just swallow up other companies as they do. So there are less and less radio companies to work for, less and less radio companies that own stations in a particular market, television, newspaper, radio. These are the issues we're talking about here. Well, the Supreme Court is looking to hear the FCC case on relaxing media ownership rules. This concerns me a lot. But again, this is something that happens so much, I don't like it at all. But anyway, here's what the story is. So the U.S. Supreme Court has agreed to hear a long-standing case dealing with the FCC's attempt to relax restrictions on local media ownership. So they're referring to the case of the FCC versus the Prometheus Radio Project to the High Court in April, supported by the National Association of Broadcasters. We talked about this on my Broadcasters podcast earlier this year. The core is whether the Telecommunications Act of 1996 allows the FCC to repeal or modify media ownership rules that it determines are no longer necessary in the public interest as a result of competition. This was really something that was brought together because of the internet. Because right around that time, there was going to be control as to what was going to happen to the internet and who's going to own what. And because there were going to be future points where the media figured they were going to have something to do with the internet somewhere down the line. Among other limitations, rules currently don't allow cross-ownership of a TV station and newspaper in the same market, and also limit TV radio cross-ownership. Because what they already did was, with the 1996 Telecommunications Act, that meant that the TV stations and the radio stations individually, which were owned by multiple companies. You could only own, I think, up to 2 AMs or 2 FMs at certain points, and then it would increase to 4 AM and FMs per market. Tonight, I think it's now 8, which is ridiculous. Because honestly, there's not one company that has successfully bought or has acquired so many stations at one time to be able to go ahead and program them successfully with different formats or having successful formats to do the such. They haven't. They're not able to. It's impossible. But the fact that they buy them all, they're basically taking away competition from everybody else. Because another local owners cannot own the stations. So we already had the point where radio ownership is gone over the top. TV is over the top. Now, we're dealing with TV and radio want to own each other in certain companies, in certain markets. And that's becoming something much more being allowed. This is what's happening right here. The full deregulation of media on the local end, which would be dire. I mean, it's going to be inevitable because of obviously deregulation has gone so much. This is why, like, when you see music companies, the big music moguls, they're owned by like 3 major companies now. We were talking about the media right now. When you're talking about all the different cable networks, the large major cable networks, they're owned by like 4 or 5 companies. Radio is owned by about 3 major companies with some other smaller end market companies that might own like 100, 200 stations. And it's just a lot. But again, this is the thing where then not enough people can get themselves onto that platform, which is why the internet is much more appealing. And which is also why people are not fighting back about it anymore, because podcasting's taken over radio, streaming's taking over music, TV, and movies. And that's what happens. Even the movie theaters, got consolidated. When corporations get that big and bloated, you know what? They're going to do the same thing and homogenize everything they're doing for other properties. That's what they're going to do. And the thing is, I'm on the perspective that we need to get some of this coming back. When we're talking about systemic and institutional injustices, you want to talk about using properties to use for good. See, the corporations, they don't want to give up any of their own properties for giving a voice. They'll throw money at a problem, right? Or they'll throw money at a situation that they're being confronted with. But, God forbid they give people a radio station to put out information, okay? They're not. Because seriously, think about it like this. When you think about 60s, 70s, 80s to the 90s. Before deregulation, do you realize how many stations used to actually cater to Hispanic, Black, Asian, Indian communities in the USA? Many. Plus other ethnicities? A lot. Nobody thinks about that. And nobody thinks about the fact that there used to be some stations that were Black owned or Hispanic owned. That was actually a thing. So why not then allow these stations to get... This is where I want the implosion of all this deregulation, in a way, where all these companies have gone so big and bloated and they can't afford to hold on the product. So then sell them off to somebody else and let them run it properly. That's the whole point. Anyway, back to the story. So among other limitations, the case dates from 2002. During a review the FCC is required to conduct every 4 years per the Telecom Act. The decision was frozen in place, decades-old ownership restrictions that have long outlived their usefulness, in light of dramatic upheavals in the media markets. The Prometheus Radio Project, which I agree with a lot what they're saying, is a non-profit advocacy group against media consolidation. It's one of several public interest groups that most recently challenged the FCC's 2018 decision and a 3-2 vote to abolish the newspaper, broadcast, and radio TV cross-ownership rules, refashioned radio FM, AM/FM regulations, and allowing one company to own two major networks affiliates in a market. Gordon Smith, the president and CEO of the NAB, said for almost 2 decades, the Third Circuit Court of Appeals has blocked common sense changes to outdated broadcast ownership regulations to the detriment of local journalism. It's time to modernize the rules. SCC Chairman Ajit Pai said that this is a breakthrough, a real chance to finally have media ownership rules that match today's realities. For 17 years, the same divided panel of the Third Circuit has repeatedly frustrated FCC's efforts to amend its rules to allow broadcasters to compete in today's dynamic media marketplace. Upon review, I hope the Supreme Court will affirm the FCC's reforms, which empower struggling news outlets to thrive in today's increasingly competitive media landscape. We're never going to get back to where it was before, but I'm really afraid of what happens here. We'll leave it there. Come back with another When I'm Not Podcasting very soon. Stay tuned right here to this channel. If you're listening, if you're watching, I'll talk to you next time.